SJC-12034, Verizon New England, Inc., and another, v. Board of Assessors of the City of Boston.
Good morning, Mr. Hazel. Why don't you wait till we're set, and then we'll get you started, okay? All right, we're all ears.
Good morning, Mr. Chief Justice. May it please the court, William Hazel of the Boston law firm of Churing and Hazel on behalf of the taxpayers in this appeal. This case is a personal property tax matter. This matter arises from a stipulated case that was submitted to the Appellate Tax Board. The taxpayers seek a partial abatement of the fiscal year 2012 personal property taxes that were assessed by the City of Boston based on the grounds that the taxes assessed were disproportional.
But the personal property tax was the same for everyone in Boston, businesses and residents alike? Am I wrong?
If the personal property tax, if the personal property was taxable, it was
Right.
it all had the same
Same
rate,
rate.
which was $31.92 per thousand. And in fact, that's one of the points the Appellate Tax Board made. This is proportional because everybody paid the same rate that owned personal property. But that's logically flawed because it's not a question of did everybody pay the same rate. The question is that rate proportional? And it's
Proportional to what?
and that's the key question, Justice Cordy. So the test for proportional, the long-established test established by this court 200 years ago, you must look at the property that is being taxed. And the assessment on that property must be consistent with its relative value. In other words, you look at the value of the property, and if the value of that property represents 10% of the total value of all taxable property in the municipality, to have a proportional assessment, 10% of the levy must be imposed on that property.
Let me ask you a question.
Yes, Your Honor.
Are you basically saying that the amendments to the Massachusetts Constitution do not have any application to the personal property tax?
I'm saying that, yes, the exception clause.
Oh, because here, the personal property tax is keyed to real estate of real property of a certain kind, the one that's assessed at the highest possible rate.
Yes, Your Honor, under
Commercial
the
rate.
statute.
Under the statute. And you're saying that there's no basis in in the Constitution?
Yes, Your
For
Honor.
saying that that's okay to equate the personal property rate with the commercial real estate rate?
Correct, Your Honor, because
So if that's the case, I don't know in this case, but, so you're saying it would be fine, therefore, if, is that better? I'm having trouble with the system
I
here.
could hear you fine already,
Okay,
Madam Justice.
If that's the case, would you, if in your example, the 10% is lower than the residential property rate, that's okay? Even after the passage of the amendment?
Yes, that would be okay, but it would be, if the statute is implemented, that would never occur, because
Which statute?
Section 56.
But that's the one you're challenging.
Yes, Your Honor. And so, for example, to answer your question, in this case, the rate applied to the residential real property was $13.04 per thousand. The proportional rate that we are saying needs to be applied to the personal property, because Article 4 does not authorize disproportionate taxation of personal property. Whatever it authorizes for real property, that's a different question. But the rate was $13.04 for the residential real property. The proportional rate that we're asking be applied to the personal property is $18.24. We're not asking for the residential real property rate or some rate lower than that rate. We're asking for the proportional rate.
So let's assume for a moment, as you suggested, your hypothetical, the total value of all personal and real property in Boston is X, and the personal component of that is 10%.
Yes, Your Honor.
So you're saying that essentially the collections from personal property can
The
be no more
assessments
than 10%?
made upon.
The what?
The assessments made upon personal property.
Can be no more than 10% of the total value of all property. So what if they were 5%? That also would be problematic? So what if the city decided to tax real property at 95% of the total value of all property and personal property at 5%? Would that also be a violation of
Well,
some constitutional principle?
again, so it's two separate, there's the Article 4, which states at its beginning, as it always has, that property tax assessments must be proportional as well as reasonable. Then we had the exception clause in Article 112 that said, except with respect to real property, the legislature can create up to 4 classes of real property, not personal property, classify those by use, and tax those differently. And then the statute was adopted that gave a formula. So the only reason I'm a little slow to respond to your question is there are rules. The municipalities cannot simply choose whatever they would like. There are guidelines within the statute. But our point is, any disproportionate taxation of personal property under the plain language of Article 4, whether it's under Section 56, whether it's under some future legislation, whether it's under an assessor practice, or whether it's under the DOR issuing an information guideline release, if disproportionate taxation of personal property results, you cannot find authority for that anywhere in Article 4.
Mr. Hazel, if the rate were to be determined by putting the value of all personal property in a city into the numerator of a fraction, and into the denominator you put the value of all the 4 classes of residential property plus the value of the personal property,
Yes.
would that satisfy you?
Yes, that's exactly what we're arguing. In other words, to determine the share of the levy that should be imposed on personal property, you must do exactly what Your Honor just said. You put in the numerator the value of the personal property, and you put in the denominator the value of all taxable property, and that gives you the valuation percentage. You then apply that percentage to the total levy to be raised, and that's the proportionate part of the levy that must be applied to personal property. And I can give an example from the record in one of the tax bills in this case, if Your Honor would find that helpful. The RCN LLC tax bill, which is at page 571 of the record appendix, the total value of that property that was taxed via this tax bill, so an assessment was made on that property, the value was $48 million and a little higher. The total value of all taxable property in the city of Boston for fiscal year 2012,
Real property and, including real property
yes,
and personal
real property, personal property, but must be taxable. It doesn't include exempted property. There's no issue of any exemption in this case, but when you do this calculation, the exempted property comes out because it's not part of the taxable base. But 48 million in the numerator, roughly, 88 billion in the denominator, and these numbers are in the ATB opinion, that comes out to a percentage of 0.0547%. So my client, RCN LLC, in this property tax, when they were assessed the tax, it should have only been assessed 0.0547% of the total levy, but it was assessed.
It strikes me that the problem, there's an arithmetic problem in your analysis, and that is you have to start with the value of all personal property and put that in the numerator, the value of all personal property and put that in the denominator. You're taking the value of RCN's property and putting that as the numerator.
Yeah, no.
And that's not the way to do it.
Well, Your Honor, I'm mixing two things. It's two different things. You can look at this with respect to all personal property, or you can look at it with respect to each assessment. So if you look at it with respect to all personal property, for fiscal year 2012, if you put all the personal property in the numerator, and you put all the taxable property, both real and personal, in the denominator, that percentage of the value of all personal property was 5.1%. But in fiscal 12, personal property was made to pay 8.9% of the levy. So that's the global calculation, if you look at all personal property. But it applies equally to each and every assessment, because each assessment must pass constitutional muster. Each assessment must be proportional, except as otherwise allowed by the exception clause, which relates only to real property, not personal property. And this case is just that simple.
Now, before Article 112, it was true that personal property had to be taxed at the same rate as real property, correct?
Yes, Your Honor.
But didn't Article 112 change that?
No,
Because it
Your Honor.
allowed, you say it did not.
No, it did not.
It allowed you to separate real property into 4 categories and tax them separately. But you say you have to basically take the composite of all those, and that's your rate. We take the composite of that plus all the personal property. But why is that? I mean, the ATB essentially says what's proportional now is that everybody who has personal property pays the same, and it's a matter of rational basis as to whether or not you go for the 13.04, the low realm, to the 31.92, that's now within the discretion of a city or town, and they can do that as long as it's the same rate for personal property. Why is that not right?
Well, I would say respectfully, Your Honor, the definition, the word proportional was maintained in Article 4. When we get down on our hands and knees and read Article 4, it still states at the beginning in relevant part, the legislature is only authorized to impose proportional and reasonable assessments, except with respect to real property, they can do usage classification, and they can implement the specific permissible disproportionate taxation of real property under that's allowed by the exception clause under its terms. But this is straight constitutional construction or statutory construction. The words are very plain. The proportionality requirement was never eliminated, so it continues to apply to personal property.
But you're still proportional to industrial and commercial.
No, we're the same, I'm sorry, Your Honor. We're the same rate.
Right.
Being the same rate does not mean proportional. That is,
But, I mean, if you look at it in conjunction with Article 112, it's, I mean, I take it that the argument is it's changed the ball game as to, it has to be proportional to one of those 4 rates, I would say, and what the legislature has chosen is that it's proportional to the commercial.
but
Right.
if I respectfully may, Your Honor, you're equating the word equivalent to proportional. Again, the test for.
I'm using the old same tax rate.
Right, but it's, the same tax rate is a shorthanded way of saying, and it is true in the old days, or if there's a flat rate now, everybody gets the same rate. But that's sort of a shorthand expression. When you actually are sort of strictly and studiously trying to determine whether a tax assessment was proportional, you have to go back to the more detailed calculation, which is, what was the value of this property?
Today, I take it, even though a city or town may discriminate between types of real property, they don't have to.
That's correct, Your Honor.
And if they didn't do that, if they had a unitary rate,
Yes, Your Honor.
the rate for personal property would be set by putting all the personal property in the numerator and then all property, real and personal, in the denominator.
Yeah, well,
And you're saying that Article 112 simply didn't change that.
That's correct, Your Honor. That's correct. And we have to be guided by the words of Article 4 as it's always existed. And if I may, Your Honor, 'cause this is a crucial point. This is construing the Constitution as written and enforced for 200 years. And all you simply have to do, and respectfully, this is what the ATB didn't do. You need to read the relevant language from beginning to end. You don't just skip to the exception clause. The proportionality requirement continues in place, and it requires, as to personal property, proportionality. The exception clause does not refer to personal property.
Let me just ask you this, though. I appreciate the fact that the opinion of the justices doesn't bind.
Yes, Your Honor.
I understand that. But it was looking at life as it existed with Article 112 passed.
Yes, Your Honor.
And interpreting at least its view, the court's view at the time, was that this kind of structure was permissible. I get that it's not binding, but I guess my only point is, it was a court much closer to the time of passage who was looking at this and, thinking it wasn't the question before the court, but thinking, yeah, that's okay.
But respectfully, Your Honor, the issue wasn't addressed.
I mean, it's sort of addressed. I get that wasn't one of the questions
It was not one of the
asked. No,
questions.
I appreciate that.
And you have the footnote 9, right, which says specifically, footnote 9 says, we consider the bill in its general applications and not in any particular application. This is a particular application where these taxpayers, for every $10,000 of tax they should have paid on a proportional basis, they paid $17,500 for every $10,000.
So I gather that if they had decided to use the residential rate of 1304, you would say, that's unconstitutional, we need to pay more.
Exactly, Your Honor. That is exactly correct. We are not asking for a disproportional rate. We are asking for the proportional rate, and I would respectfully submit that the words of the Constitution alone are the guide, and only the people can change those words. I see my time is up.
All right, thank you.
Thank you, Your Honor. Thank you.
Mr. Ambriano, good morning.
May it please the court, Anthony Ambriano for the Board of Assessors of Boston.
Could you explain to us why Mr. Hazel's wrong about his numerator-denominator formula?
Certainly, and first, with respect to the issue of personal property as a whole, which was discussed by Mr. Hazel and Mr. Justice Spina, the taxpayers assert that pre-Article 112 amendment, that there was a constitutional requirement that personal property as a whole bear its proportion of the entire tax levy, as that personal property as a whole bears to all taxable property. That is not the case. Article 4, prior to its amendment, speaks only that taxes shall be reasonable and proportional as to estates. It did not deal with real estate. It did not deal with personal property. It dealt only as a whole with estates. The rule has been that for an individual taxpayer, prior to the amendment.
Excuse me, could you stop there? You're saying that something happened with the Article 112 amendment? That
Yes.
changed Article 4 as to personal property?
I think that Article 12 brought in, as a constitutional amendment, an entirely new meaning of what is proportional.
Look, before you got there, though, I mean, what you said before that, though, sounded to me not consistent with Bedigol. Am I wrong?
No, Bedigol, of course, dealt with extreme activities by a certain board of assessors,
Okay,
whereby
but it
the
sort of
board
had-
was doing de facto classification of not only personal property, but also real estate. The issue has always been, and I think as noted in Bedigol, that at the individual taxpayer level, that taxpayer's taxes must be proportionate to the value of that taxpayer's entire estate. There has not been any case, and there are a couple of cases mentioned by Verizon and RCN, arguing as to pre-Article 112, a global requirement that personal property as a class bear its proportionate share of taxes.
It sounds like you're advocating for rates of taxation, as many rates of taxation as there are taxpayers.
No, not at all.
So it's not determined by the estate of the person?
No, Article 12, as amending Article 4, proportionality is maintained. However, with Article 112, as pointed out by the Appellate Tax Board, it is no longer possible for all taxpayers to pay the same rate.
Right.
That was the fundamental rule prior to the amendment.
So you are suggesting that there are as many tax rates as there are taxpayers?
No, because that would not be permitted under either the amendment or the statute.
What you're saying is that, in effect, Article 112, although it deals with real property, necessarily has an impact on personal property.
That is-
Because it effectively changes the definition of what proportional is.
That's precisely Boston's argument.
And so, would you say that under Article 4, as amended by Article 112, that a statute could be passed, or a city or town, I take it, could do, where they would set the rate for taxing personal property at a different, not at the commercial rate, but at the residential property rate? Could they do, I mean, why would they do that? I understand that, but could they
Right.
do that?
Conceivably, that could be done. The issue now, under proportionality, is proportionality within its class of property. I would also suggest and agree that those classes cannot be arbitrary, bearing in mind that the Article 112 only allows the legislature to set up 4 classes of real estate. It does not specify what those classes may be.
So under your theory, if a town had to raise $12 billion, or a city had to raise $12 billion, it could levy, create a tax levy against personal property that would raise $11 billion of those $12 billion, under your theory.
Well, there are 2 issues here. One is, of course, proportionality, and the second, which Verizon and RCN claim they are not raising, is equal protection.
But I'm just trying to understand, under your approach for getting equal protection, a town could levy $11 billion out of $12 billion needed for its to operate against personal property.
As long as the personal property was everybody was treated equally within that class.
No, I think that would raise a serious constitutional issue, because one of the key points made by the Appellate Tax Board is not only that all personal property is treated equally, but personal property is treated the same as commercial and industrial property.
I had thought, correct me if I'm wrong, I thought the Appellate Tax Board said essentially you can tax them anywhere from the residential on the bottom end to the commercial on the upper end, but only within that realm.
I would suggest that if it is the same as a rate applied to another class, that would be constitutionally permissible.
And now, but he says it should be 1824, which is not the rate right now assigned to any class. Would you say that is unconstitutional even if the city chose to do it?
That is correct.
So
That would be singling out.
So you say it can't be the midpoint between the residential rate and the commercial rate. It has to be the commercial rate or the residential rate?
Or whatever.
Or the
rate.
open space rate.
Or
Yes.
or one of the 4 rates.
Correct.
It can't be
And
anything
the-
other than one of the 4 rates. And why is that?
Well, because first of all, the range of the rates is governed by the statute. The Department of Revenue sets a so-called minimum residential factor.
Okay, well, let's assume that you have the residential on the bottom end, which I think is 1304, and then the top end is, I think, what, 31?
3192.
You're saying that that's not your range. You have to choose one of the 4 rates applied to commercial property, applied to real property.
Yes, you would have, the statute will produce 4 real property rates.
Okay, and why is it that with Article 112, personal property has to be one of those 4 rates?
Well, it goes to the very essence of what proportion is.
Well, I
If
know,
it were
explain-
lower,
Explain to me why that, what that means, in fact.
if personal property were taxed a lower rate, it would seem that the real estate taxpayers could conceivably have a claim for disproportionate assessment.
Okay, now, I get it why it can't be below 13.04. I just don't get it why it has to be one of those 4 rates.
Well, certainly that happens under the statute. Constitutionally, could the legislature revamp the statute?
So you're saying it's not constitutional, it's because that's what the statute says?
Yes.
The statute basically says, pick one of the four rates, pick one of the four real property rates, and that's your personal property rate.
Yes, and I think it's important, in looking at the constitutional issue, that the discretion of the municipalities is not unfettered here. And there has been, it is stipulated that Boston followed all the correct procedures. Going back to the Springfield case, Boston certified full and fair cash value. The Department of Revenue computed the minimum residential factor.
Can I go back to something? You said that the appellate tax board says, and you agree, that once Article 112 happens, it means the definition of proportional has changed for everybody, not just for real property, but also, in effect, for personal property. Why is that?
Because it is no longer possible, once a municipality has classification, has made the election. Once that happens, it is no longer possible for there to be one rate applied to all property. Now, we know there are going to be multiple rates.
Right?
That is now a given under the statute. Once there are multiple rates, the question is, does the statute and has Boston achieved proportionality within each class?
For real, I mean, arguably, for real property, yes, but I mean, this is the taxpayer's argument. But that's fine for real property, that's on that side, but nothing's changed for the personal property, and you have to go back pre-amendment because it's an exception.
I would disagree, because all of the pre-amendment case law essentially deals with the issue that all property be taxed equally. Once that requirement is gone, and it is gone after the amendment, then the question becomes, well, what is proportional? I mean, and this court did note, even in the understood non-binding 1979 opinion of the justices, the court noted and found that as the residential factor goes down, this court said the taxes on commercial, industrial, and personal property will increase. And I submit that
So is part of your argument that the history of the amendment is that it was passed, and everybody understood that it was really intended to deal with public concern about real property taxes going up?
absolutely, it's well acknowledged that it was a reaction to the requirement of 100% valuation. It was certainly became clear as long ago as the Bettigold case that this was not something that assessors should be dealing with on a haphazard or de facto basis, that there should be a rational system for implementing this.
So help me with Justice Spina's question asked of your brother. I mean, he says that if Boston had not embraced Section 56, and because Article 112 gives a city or town the authority to do so, doesn't require it to.
Yes.
If it did not, you'd be taxing all property, real and personal, at 18.24.
That would be the arithmetic.
Okay, but you're saying that because you can now tax commercial property at a higher rate than residential property, you can now increase the personal property rate from 18.24 to 31.92, that's the practical consequence of the article, that it allows a city or town to increase the rate, not only a commercial property versus residential, but of personal property over what it would otherwise have been.
Yes, though again, we have heard talk of a rate of 18. There is no rate of 18.
But
No class of property.
that would be the rate if you did not divide it into 4 classes.
Correct. If there were no classification whatsoever, that would that would be the rate.
And do we have, and, I'm sorry, go ahead.
Oh, go ahead, finish.
Do we have any, in terms of the legislative history of the amendment, any recognition by the legislature that this would give a city or town the authority to actually increase considerably its personal property rate?
I think it must be assumed that the legislature, when it enacted the statute, had gone through the arithmetic, as this court itself did in 1979 in great detail. And this court went so far as to recognize.
Well, the court recognized certainly that commercial rates would be higher than residential rates, but did anybody recognize that personal property rates would now arguably be higher than they were?
Well, the court recognized it in its 1979 decision.
That it would be the same as the commercial rate.
Yes, and that it would be, as the shift occurred, that the shift would be from residential to commercial, industrial, personal property.
So, I'm going all the way back to the beginning. Proportionality regarding personal property tax now means what?
It means proportional within its class of property, and it means not higher or not being discriminated against in any way. We have a very specific statute with very specific guidelines.
And not discriminated against? What does that mean?
Well, you couldn't single out personal property and say that the computations provide a rate of $31.92, but we're going to hit them because they're telephone companies at $35.
But you are discriminating against them because you're setting, you're at least allowing a city or town to set a tax rate for residential property in a discriminatory manner. I mean, that's the essence of Article 112. It allows a discriminatory treatment in favor of residential and open space lands.
It does. 112 permits that shift, and that in fact was the purpose of 112, to permit a shift. The fact that a tax is mathematically disproportionate does not mean it's illegal. And
But the Article 112 does not address personal property specifically. It only addresses real property. The discriminatory treatment within categories of real property.
that is correct, and I would also point out again, though, that Article 4, prior to the amendment, never treats personal property as a separate class.
But you would say, wouldn't you say to Justice Spina that although it doesn't address it, it's the inevitable, implicitly it does. Inevitably, implicitly it does. I mean, in other words, to give effect to Article 112, it has to be that personal property rates and the definition of proportionality gets changed for everything.
It must change because, again, there is no longer a rate where you can say everything is now taxed at the same proportional rate. It's just impossible to happen under the statute. The legislature certainly would have considered that in enacting the statute pursuant to the constitutional amendment.
Help me understand what I should already know. The personal property that the city of Boston taxes is personal property owned by whom?
Everyone.
Everybody.
Subject to the many exemptions for personal property, yes.
Okay, so I mean, I guess you can basically, a dishwasher in somebody's home would be personal property that's taxable?
Only in their vacation home.
Because of an exemption or because of the definition of personal property?
No, because of exemptions for,
Basically, personal property is everything, and then you simply exempt a lot.
very much is exempted, yes.
As you do real properties.
Yes.
The whole series of exemptions with regard to real properties.
Exactly. There are even more for personal property.
Okay.
Okay.
My time has expired. Thank you very much.